management, or like Charmaine over there, she has to be here to get some community education hours, but we certainly appreciate your presence here. A bit of a review. We had Judge Madrigal 2 weeks ago talk about search and seizure. I'll tell you what I remember from that presentation was, is it a valid search and seizure? All I heard was, it depends. Right? It depends. So we operate in the gray area a lot when it comes to searches and seizure. Last week we heard Judge Alicia Lattimore talk about problem-solving court, a bit more uplifting, right? We don't always, there's a category of people who may commit crimes or do something to get their children taken away from them in dependency court, and rather than just lock them up or try to move the child somewhere else, it's a problem-solving court that tries to help if they can, and that was fantastic as well. Tonight, maybe not so harmonious, but tonight we hear from Judge Diana Tennis regarding primarily divorce court, I believe. And I can't think of anyone better than Judge Tennis to talk about divorce, not because she's been divorced, but because she's literally handled divorce cases as a judge for at least 11 years and as a lawyer for probably 20 plus years. She knows quite a bit about divorce. But she was elected to the office of circuit judge in 2015. She served in Osceola County. We've talked about that. There's 9th Circuit is Orange in Osceola County. She's served in Unified Family Court in Osceola County, done probate, mental health, and guardianship court here in Orange County. She's been associated administrative judges. She's been administrative judges. Since 2020, she's currently the administrative judge for family court. So not only does she handle her own docket, all judges who work in family court take their problems to Judge Tennis, and lawyers complain to her as well. And it's a lot of work, and we very much appreciate that. Before becoming a judge, Diana Tennis was a highly respected and talented trial lawyer, both criminal defense as well as divorce. Many high-profile cases. There was a time where every time I turned on the TV, I thought I saw Judge Tennis. As a lawyer, she certainly knows her way around the courtroom. She loves to get things done. As a judge, she is efficient. From what I have observed of Judge Tennis, she is driven to get the right answer. I find her to be a ton of fun, and I can't promise she's going to make you laugh tonight, but I think she's got a great sense of humor.
Thank you.
There's no pressure on that for you.
No, none.
The only other thing I will say before I turn it over to Judge Tennis is she is a double gator. Now, undergrad in law school. Every judge who's presented this these sessions has gone to law school in Florida. We do not have a bias for or against any law school, but all I can tell you is that we draw from a very large pool, and it just seems as though the cream will always rise to the top. So maybe no coincidence that we have yet somebody else from the University of Florida. Please help us welcome.
Thank you. Hi, good evening. It's great to be here with you. I love questions, love conversation. I think people always ask the things that I should be thinking to talk about instead of the things I brought to talk about. So feel free to ask questions. This is my 11th year on the bench. It's hard to believe it's gone so fast. Before I got elected in 2014, I was a criminal defense lawyer and a family lawyer. And I have to tell you that I was not in love any longer with being a family lawyer. It's so hard. I don't know if you've ever been in a family courtroom. It is a pressure cooker. Lots of unhappiness. Lots of people just on their worst days. Every day is a bad hair day when you're going through a divorce. Very, very stressful to represent folks and carry that energy with them, and they, around you. It's stressful to try to worry about what the other party's going to do, what the other lawyer's going to do, what the gosh darn judge is going to do. I wasn't crazy about it. So then I became a judge, and now I got to tell people what to do. All of a sudden I was like, this is a whole new thing. This is not as bad. This is much better. And I felt like I actually could do some good. I could listen to everybody, be as patient as I could possibly be, some days better than others. And I could really feel like I was making a difference. I could do things faster, more efficiently. I could give people a chance. I could do what I thought was right for kids. I could lecture people about how bad they were being as parents. And it just opened up my eyes to a whole new world. So now not saying I don't ever get frustrated, I'm not saying that. And not every day is a picnic, but I really feel like I am doing more good for more people than any one lawyer out there in the world could do. I've got 3,000 cases. I got a lot of opportunities to mess it up, but I have a lot of opportunities to do a really good job for people. So that's when I get my new judges in. So we have 6 divorce family judges, like the division that I have, and we have 4 DV judges. They're in domestic violence injunction court, and they also handle some divorce and paternity cases. So where there's 10 of us here in Orange County, I've got 3 more in Osceola County. So we have a lot of us. We get along great. We have meetings. It's wonderful. And when we get new people in, typically they don't have any experience in family court. They weren't family judges, or family lawyers rather. And so it's a big learning curve. And so I spent a lot of time trying to mentor and try to help them get used to the job and to love it the way I love it. So I'm going to talk about some kind of nuts and bolts of things. Again, I like to talk, so whatever you want to talk about, you tell me, and I'll answer your questions. This is what I find is the rub between the litigants and the judges in family court. So we have 60, I don't know exactly the number, but probably 60 to 70% of folks in family court do not have lawyers. A lot of them start with lawyers and then they run out of money. It's really expensive. Lawyers in this town go anywhere from low end of $300 an hour to high end of, there's a few out there charging $800 and $900 an hour. That is an immense amount of money that you need to have a lawyer in family court. So most people, even if they start out with an attorney, end up without a lawyer, except for the really richy riches. And we have a few of those. They're not happier, by the way. I see them every day in the courtroom. Those people are not happier. So litigants want fast and helpful results from us. But it doesn't just happen. And one thing that pro se folks don't understand a lot, or people on the outside of the system, is we have layers of rules that everybody has to follow. Rules about what documents you have to give over, rules about when you can do things, rules about time frames when things have to happen. And we are expected to hold pro se people without lawyers, to the same standards as the lawyers. And this gets very frustrating for pro se folks, very confusing for pro se folks. Frankly, it gets upsetting for the lawyers on the other side too. Because my job, as I see it, is to make sure that everybody's treated equally, but sometimes you've just got to give some consideration for lay people who do not know what is going on if you're going to get to a fair result. And we want a fair result. We want everybody to feel heard. So number one thing I tell everybody is you've got to read the orders. I tell this to the lawyers too. Sometimes they forget to read the orders. But the orders have all the stuff in it that you're supposed to do and when you're supposed to do it. And if you read the orders, if you don't ignore that paperwork, everybody is better off. I think the problem is we are so used to in our real lives, in our outside the courtroom lives, to getting so many words on so many pieces of paper that don't seem important. And I do the same thing. I've bought a few houses in my day. Do I read all those documents? No, I don't read all the documents. My husband reads those documents. I don't read all those documents. But if you buy a car, if you go do anything, you go and get a credit card, you have paper and paper and paper with words and words and words. And I think we just get out of the habit of really thinking any of that stuff's important. Courthouse stuff, very important. It's different. You got to read all the words, all the words. I create words all day long. I really want people to read them. I really do. So you can't see the little line. I made it actually too small. It says if you can't read this, you're going to lose. People do not have good penmanship. I know this is going to shock you. I get it. I don't have good penmanship. And I do that thing where you write on the Post-it notes and then another Post-it note, and pretty soon you've got this trail of Post-it notes. It's ridiculous. So that is like the number one thing that I would tell a person who's trying to represent themselves in any kind of court case. If the judge can't read it, you're not going to get what you want. It's simple, but it's really, it's powerful information. If you can type it all, the better, but you've got to be able to read it. So before the trial in a divorce case, lots of things happen. I know that people file a divorce and they think, like, you know, maybe this will take a month or maybe this will take 2 months. The average divorce case, even when you're not fighting like cats and dogs, is a number of months. Because even if you agree on everything, it still takes that much time to get through the system, unless you have a lawyer. The fastest you could ever get a divorce in Florida is 20 days after filing. So if you filed your divorce and had your written agreement and had a parenting plan if you've got children and all of your ducks in a row and all of the other miscellaneous forms, and you filed it and you had a lawyer who was jumping on it, 20 days later is the fastest. But that honestly just never happens. And if you've got a few things that you're fighting about or a few things that take you a while to come to terms on, it is going to take many months and it can take years. It is routine that I will have a trial. This breaks my heart. It really upsets me. It is routine that I will have a trial that will be going on for 4 or 5 or 6 years. Some situations even longer. And it's just, time goes. Time goes really quickly. Things move very slowly. Lawyers are really busy. Judges are really busy. And things fall through the cracks. It's a very horrible way to sort people's lives after their breakups and to sort children's lives. It's a horrible process for that, but it is what we have. So the way to make it easier, better, is to make sure that you're on top of it and doing all the things that need to be done. So pleadings drive everything, meaning if you don't ask for it in a piece of paper, the judge can't give it to you. Oh, we have a question. Go right ahead.
Can I ask you a question? Okay, so
Sure.
for a case that go through 5, 6 years, a lot of things have happened. One party may have died. You know, so before, say, when we are having a divorce case, we are fighting for the Ferrari. My husband and I are fighting for that Ferrari. That's why the case has been going for 5, 6 years. And suddenly he passes away. So I become a widow. I don't need to fight anymore.
So I want to make sure I understood the question. Was the question what happens if one party passes away during a divorce?
Yes, and then what happened to the assets that we have been fighting so hard for?
So the technical answer is a fairly short answer. If a party dies during a dissolution, a divorce case, the case is dismissed. It's as if it was never filed. Now, it gets a little bit more complicated if there have been agreements and orders having kind of doing things with the stuff, but the divorce itself goes away. It may be that some of the agreements stick for the heirs or things like that, but in general, that is you have to have two living litigants in a divorce case for it to go on, is the short answer to that question. Yes?
So, in the scenario where it is dragging on forever,
Yeah.
and where they have agreed on everything, rather than drag things out in Florida, why not just fly out to Nevada and get a quick divorce? They agree on everything.
Well, I didn't know you could get a quick divorce in Nevada. I don't know what their residency requirement is. So most states have residency requirements to prevent that. Now, maybe Nevada doesn't. I don't know the answer to that. I know I've heard of the Quickie Dominican Republic divorce. I think that's the only place I've ever heard of that had a very, very fast.
Out of it, the Dominican Republic instead. Doesn't that make sense? Just go there for a weekend.
I think you totally could. I think you totally could. Now, if you have, like we have in the Ninth Circuit, we have a group of people that work behind the scenes. We call them, these are our case managers. And if you have two people that don't have lawyers, they kind of manage those cases. And at the point that they've done the paperwork and they have written agreements, they should be in the pipeline to have a final hearing. So the cases where things go on really long are cases where people are not in agreement, or they're in agreement to 50% of it, but not that 50%. It's the disagreements and the trying to work those out in the court system to get to where you can have a trial in front of a judge who's got 3,000 cases. That's where the real lag time happens. Yes?
So if a couple owns a home and they're getting a divorce, and they're getting a divorce, is the couple that decides to move out automatically at a disadvantage later on?
This is a great question. No, they are not. So if a husband and wife own a home, and frankly, even if the home is only in one of their names, but they got it during the marriage, if it's a marital home acquired during the marriage, then they both have a marital interest in that home. It has nothing to do with who's living there. Not a thing. Not a thing. Now, if one person stays behind and they're doing the upkeep and paying the mortgage and doing those things, that can be taken into consideration. That may have an effect on some of the outcome, but it doesn't do anything about that other person's interest in the home. So I think it's a great thing to bring up, because so often when you have children involved, those kids are so much better off not living in that pressure cooker. And if somebody has a place to go that is reasonable for some period of time to not have a risk of that child seeing, if not domestic violence, then at least very unpleasantness, that's generally, I think, better for kids. So that's a great question, and that's kind of the short answer to that. Let's go over here. So please try everything. Discovery is when you have to trade documents back and forth. There's a lot of required stuff in every kind of family case, because everybody has a right to know where are the assets, what do we have, how much is it worth. And you have a lot of marriages in particular where one party is much more involved in the finances than the other. And this is an opportunity to make sure that everybody's on an equal playing field and everybody knows what's all the stuff that we have and what's it worth and what happened with it. This is also a time to exchange information about incomes and things for a child support calculation or potentially an alimony calculation or that kind of thing. So we have temporary hearings where a judge can kind of put a Band-Aid on things. If you have a situation where mom and dad separate, whether they're married or not, and one of the parents has the children living with them and the other one is not getting any time sharing, is what we call it. A lot of times people will ask for a temporary hearing on time sharing. We have in Florida, fairly recently, a new statute that says I have to, as a judge, I have to presume that a 50-50 time sharing schedule is in the best interest of a child. And the parent who doesn't want the 50-50 schedule has to prove with evidence that that would not be in the child's best interest. So 50-50 is where we start, and then we listen to everything and decide whether or not that would not be in the child's best interest. So that is very shocking to a lot of people. That's very shocking to a lot of moms, to be frank with you. And so part of the temporary process for me is educating a lot of times parents who did not know that that's what the law was. And so I like to use, just one second, I like to use the temporary order, particularly for time sharing, to give everybody a chance to see how it goes. Because a lot of times the parent who's had the child most doesn't trust that the other parent's going to do school right or going to do homework right or going to be available or they're going to be working or whatever their concerns are. And sometimes they turn out to be right and sometimes they turn out to be wrong. But if you don't kind of try something for a while, it's hard to know how will people step up to the plate and be that good parent. Sometimes you got to give them a chance to see that. Yes, ma'am.
Your Honor.
Hi.
Just out of curiosity, I forgot when the statute changed to 50-50. If you might be able to...
The when?
When the statute changed as far as...
July of 23. July of 23? Am I right about that? I think it's July of 23. Was it 24? Now that you got me questioning myself. Was it 24? Was it 23? Okay, I thought it was 20. It's just like time goes so much faster than I think. I thought it was either last week or it was 2023. Yeah. I'm sorry?
No, my question is when, because I remember back in the days, used to be like primary custody.
Yeah.
So when that came, I know it's been a while since the 50-50 is in place. My question more out of curiosity would be what year was when that actually was in full force and effect? I forget. I wrote it here.
So I believe it was 2023. Yeah.
That's all
Yeah.
I wanted to know. Thank you.
You're right, it doesn't seem like it's been, well, I don't know, it seems like it's been that long, it hasn't been that long. COVID brain around dates, I don't know anything anymore. Yeah.
Are there any time provisions for grandparents?
The question is, do grandparents have rights in the state of Florida? The almost straightforward, simple answer is no, but sometimes it depends. There are some narrow situations that are pretty unusual that would have to involve kind of bad acts on one parent to another parent. If you had one parent that killed another parent, you might have, there's a statute that might give you a little a way to get in. There's also like a temporary custody order. If you are a grandparent or a maternal or paternal aunt or uncle and have the child living with you and have either consent by the parents or can prove that they're not fit, you might be able to get a temporary custody order. But that's a little bit different than visitation. There isn't any grandparent visitation rights in the state of Florida currently, but those things tend to change a little bit over time. So negotiations, big part of all of this, and trying to narrow the issues is always part of the thing. So due process, this is also something that people don't totally understand, is every single thing that gets sent to the court, it's filed with the clerk's office, a copy must be sent to the other side. Every single thing that comes to my office by email primarily, the other side has to be included. Our goal is due process, which means I'm never looking at anything that only one person has sent me. Everybody always knows everything that we're looking at, which is why we are really careful about not having kind of private conversations with litigants. It's why I wouldn't handle my best friend's divorce, because you want the judge to be fair and not have a partiality to either side, and you don't want anybody in the courtroom to think that the judge has a partiality. So we take that really seriously, and we try to work really hard to make sure everybody knows that we're not taking sides and we're not listening to just one side. So this is a big part of family law. Also, we have, you might see on a movie, a criminal trial where a lawyer will stand up and go, "Well, sir, isn't it right like this?" And the witness will be like, "Oh, I never saw that. Oh my gosh, it's such shock and awe. It's such a Perry Mason moment." We don't have any Perry Mason moments in family court. Everything that you use evidence-wise at a trial, everybody has a right to see ahead of time. So nobody's ever shocked by those pictures or by those text messages or anything else. That's another big part of what makes family a little bit different, is we really want to get the best high-quality result without lawyers being able to kind of outmaneuver each other, and it should never be about who's got the best lawyer in the room. I have cases all the time where there'll be a lawyer versus a layperson, and the pro se person will end up prevailing, much to the consternation of the lawyers, but sometimes they just do a really good job for themselves, honestly. So we deal with all kinds of cases. They usually start with a petition. So petition for dissolution, which is a fancy word to say divorce. We have paternity cases. We have modifications. So that's usually kind of how things get started. You have a right to be served with a petition that's filed in family court. That's either done personally, usually through the sheriff's office. They're handing the person the paperwork directly. It can also be done somebody who lives at their home, or if the person cannot be found, you can do it by publication. But you really have to prove to the judge that you can't find that person, because we don't want people being divorced without knowing it if you could possibly find them. So that's kind of how the processes are started. Then we have a discovery period. Financial affidavits are always required. They're lengthy, they're detailed. So it gives you an idea of not just of what people are earning for purposes of child support or alimony, but also tells you what their expenses are. And that's a big deal when it based on what your need is. And your need is typically what your net income is minus your expenses. And what you're short every month is generally kind of what is used for your need for that concept. We have, I mentioned before, we've got to be able to read things. We want details, but not long. I know that sounds contradictory, but it's got to be enough to whole sentences so that we know what you're talking about, but not so long that it's got the whole kitchen sink in there. So this is something that even the lawyers, frankly, have a hard time with, so it's always a work in progress. So we do not use the word custody. Kind of makes me cringe when people put the word custody in a motion. We do not use the word custody. We use the word time sharing. We don't have sole custody. There is no such thing as sole custody in Florida. We have sole parental responsibility, but very rarely is that provided. Shared parental responsibility is the norm. It's presumed. I have to give shared parental responsibility unless you can prove that it would be a detriment to the child to have shared parental responsibility. Very unusual circumstances. So generally it's shared parental responsibility. Often it's a 50-50 time sharing, not always. But those are the kind of the things that the different way we talk about them, things than the people in the real world talk about things. Equitable distribution is a fancy way of saying dividing up assets and debts. So this only applies in divorce cases. If you're not married, the judge can't divide up your stuff. You're left to your own devices to figure out the pots and pans. But if you're married, then part of my job would be to equitably divide your marital assets, debts, property, accounts, retirement, cars, boats, cows. I've had the cow case. I'm not even joking. I'm not joking. And so that gets sometimes a little bit confusing. For example, if I come into a marriage with a bank account that's only in my name, that bank account on day one of my marriage is not marital. Doesn't belong to my husband. Now, if I put one of my paychecks in that account after we get married, now that's marital. My income after we get married is marital. Now it's starting to be marital. If I put anything in there that is, if his mom gives us a gift for Christmas of $500, and I put that in my account, now there's more marital money in there. And at some point, very, very quickly, that becomes all marital, because you can't really tell whose dollars is whose dollars. So that's, it happens quite a bit that somebody has something that they assume is non-marital, but then they turn it into marital stuff. Same way with a house. If I own a house only in my name and I get married, on day one, that's my house, it's not marital. Then I pay a mortgage payment. Well, that's marital money, because my income and his income, they're both marital money. Now there's a portion of that house that's going to be marital, and we're going to have to figure that out at the end if things go south. So things get really kind of loosey-goosey, which is why if you've got concerns about those kinds of things, lawyers are very important, because they can help you figure out how to keep things non-marital if that's your intention. Yes?
Common law, is that accepted in Florida? So for instance, you're dating someone, they move into your house, 7 or 8 years later, your relationship breaks up. Do they have any claims to your property or any of your assets?
The question is, do we have common law marriage in Florida? The answer is no. There are very few states that still have common law marriage. Florida is not one of them. So you are left to your own devices to figure out that breakup however many years later. There's still, if you owned a house together and were not married, there's a partition action. You could still take an action to try to figure that out legally, the house, but the rest of the stuff, very difficult. But yeah, we do not have common law marriage.
What about religious marriage in Florida? Some people say they got married religiously at church and that's it.
That is between them and their God, and that one will not be my problem. Yeah, that a religious ceremony will never, it doesn't create a legal marriage, and I only have to deal with legal marriages. Now there are some interesting cases though. There are some interesting cases out there related to religious divorces and whether or not getting a divorce in a country that doesn't do things kind of the way that we do them, and whether or not that means you're divorced when you come back here. There are some very interesting cases out there about that, and that could get a little bit trickier.
A little bit more.
I'm sorry?
Can I elaborate a little bit
Sure.
more? I am a pastor, so sometimes I have some members coming from a different country. They believe that I can officiate their religious marriage until maybe later or 3 years later or sometimes later they can do the legal marriage. They simply want to fulfill a religious requirement versus fulfilling a legal requirement. So is it a wrong thing to do to religiously officiate their marriage?
So I would never say that it's the wrong thing to do. I would say as long as they understand that they are not legally married in the eyes of the state, and if something happens and 2 years later one of them thinks that they have rights that accrue because you're a married person, they will not have those rights until they are legally married. And for example, for purposes of, just as an example, purposes of alimony, the length of time that you've been married is a very big factor in how many months or years you might receive alimony. You will not be considered married until you're married legally. So it may have an impact on them, but that impact notwithstanding, I think that there are people who want to do one without doing the other, and they have every right in the world to do that. Yeah, sure.
What does common law mean? I mean, I've heard it so many times and I don't understand what it is.
So the concept of a common law marriage is an old-fashioned thing, and I'm trying to figure out how to put this tactfully. I think that the thing that was being fixed is that women were not getting married as proper women do. And we were taking care of those women who were in lengthy relationships, who held themselves out to the world as being married. We were helping protect them against being jilted and left with nothing. So if you were, North Carolina may still have common law marriage. I know when I was practicing, sometime in the last 20 years they did, because I had a case involving that. But so if you held yourself out to be married and you act like married people, at some point it stuck, and a judge somewhere was going to say you're married, they have a right to some of your property, they have a right to split your stuff, they have a right to potentially alimony. It was to protect women, essentially. But surely over time, that became less of a thing. The needing people to be married, to live together, became less of a thing, and those protections got loosened up, and so very, very, very few states have that any longer. And it's hard to keep, like, it's so subjective also. I think was probably also part of that thinking is, what's the fine line between, oh yeah, I call him hubby, or I call her my love, like, are you married? Like, at some point, most states decided we want people to affirmatively say they want to be married. And if you don't, then you're not going to get the protections. But that's what common law marriage means. Question? Oh, yeah, yes.
I have another question about access.
Okay.
Okay, so, so say one party is from another country, and honestly, there's no way you know what I have back home. I mean, so the question is, as a judge, I mean, is it your job to verify that both parties honestly declare their assets, or you just take their word for it is?
So the question is, do people lie? No, that wasn't your question. But the answer to your question is people lie. The question was, how far do we as judges have to go, or should we go, to verify, the question was about assets, but to verify what people are telling us is the truth. And I will say that I am very limited in what I can do to suss out the truth. So in your example, the people have property overseas. This is very typical. Lots of people have property overseas. And so they've got an apartment in Bucharest, and he says it's worth $100,000, and she says it's worth $200,000. Chances are I am never in a million years going to know which one of them is anywhere close to the truth. They might, if they have lawyers, they might have appraisals. That's always fun, reading documents in a foreign language and trying to figure out what they mean and what the exchange rate is in the money, and that's always very confusing. So you learn to ask hard questions. So in this example that I'm giving you, like the party who doesn't have possession of the item usually wants to value it really high. And the party who has the possession, it's not worth very much. It's really, I want to value down here. So usually I start with, okay, you think it's worth so much. Would you like to buy it for that? Because I'm going to make her sell it to you for that. And then they go, no. I don't want it. I don't want it. I just want you to value it really high and put it on her side of the ledger. So you ask things like that, and usually you can get them down to something in the middle. And sometimes it goes to trial. The thing that people don't realize is before the trial, I can work on people. I call it massaging them. I work on the people, and I try to get them to agreements, to something that's reasonable and gets it done. If I can't do that, we have a trial. And then I can't pick a number in the middle. So he says 200, she says 100. I literally cannot pick a number in the middle. I have to have a reason for the number I pick. He's given me a reason to pick this one. She's given me a reason to pick this one. Generally, I have to find one of them more believable than the other and go with it. Now, I can value it at his number and give it to him, and usually with some warning. So you can do that. But it does get very, very tricky. Lawyers are sometimes helpful in ferreting out the truth about those things, but sometimes even they have a difficult time. And sometimes, I'll be honest, I think this gets lost in the shuffle. If you've ever had a breakup, haven't we all? I always want to say to people, I remember my breakups, it was like, what of this stuff do you want? I'm taking my cats and getting the heck out of here. So I think people lose track of fighting over money. It really is just money. It's really just money. Go make more. So I try to also have people look at things in perspective. In the perspective of, is it worth 200? Is it worth 100? In the big scheme of things, it doesn't really matter. Let's pick a number and move on. But that is definitely a challenge. We do not have a system of courts here like they do in other parts of the world, where judges have a more active investigatory kind of deal. We don't do things like that here. Here, the evidence is supposed to come to us. We're supposed to do something with it, and then we make decisions from it. So we don't go out and investigate things. And if we did, for example, if I called up my buddy, the realtor, and said, hey, this Bucharest property, look it up. What do you think? What do you think it'd be worth? That would be completely wrong of me. Completely wrong of me. That would be utterly unethical of me. So it's almost the opposite of do I go out and look for things? No, I don't. I wait for it to come to me and do the best I can with it.
So do you wait to forensic accountants? Let's say someone hires a forensic accountant.
Yes. So,
That means something to you.
so yes, when people bring in professional financial people, that can be very helpful. If you have a complicated business, family-held businesses are very challenging because most people who run their own little business do a very bad job of bookkeeping, and they're running their personal stuff through it, and it's their piggy bank over here, and they're paying this stuff over here, and it gets very difficult and then they fill out their financial affidavit and say they're making $5 a month, and it gets very difficult. So if you've got the money, it takes money to have a professional go through those documents, it really helps you a lot. Or I look at things like how much did they spend? You say you earned $5 a month, but you spent $6,000 a month, and you don't have any credit card bills. I think you're earning what you're spending. So there's other kind of sneaky ways we could go, like try to figure out what people are actually earning, but that is challenging. Yes, ma'am.
I happened to look up what states still have Commonwealth, and there's 8 of them. There's Colorado, District of Columbia, Iowa, Kansas, Montana, Oklahoma, Rhode Island, and Texas.
Rhode Island's a weird one. The other ones are not so shocking to me, but Rhode Island's a little weird. Well, I guess we know where not to say a hubby if we don't mean it. You got to really mean it. Hi.
Just wondering, in your experience, what's the most popular reason people get divorced? And have you ever had a case where in the middle of all of that they reconcile?
So it's so interesting that you asked this question. I'm going to do the second one first. So I was literally on the phone with a friend judge of mine today, Chris Brysensky, who's this great guy. He's in Seminole County, and he said he had this litigated trial with 2 good lawyers, and the divorce trial had been going on, or the case had been going on for 6 years. 6 years. He said he knew there was something different when they came into his courtroom. I literally had this conversation with him today. So they come into his courtroom this morning, and he says, the husband pulled out the chair for the wife. And he thought, well, this is different. And so we going through the questions, and one of the questions that you have to ask in every divorce case is your marriage irretrievably broken? All right, you've probably heard that on TV. And so he asked the question, and there was this long, dramatic pause, and nobody's answering it, and he says, are one of you? And he says, the wife was sort of like, well, yeah, no, I guess so. And he's like, you're in your trial. We're here in a trial. So, yeah. So he goes to the end. He gets to the end of it. He tells him what he's going to do. Da-da-da-da-da. And he says, I find that your marriage is irretrievably broken. She raises her hand and says, I don't think it is. and he goes, well, I looked at the husband. I said, well, sir, what do you think? And he goes, well, I'm not sure it is either. So he goes, well, why don't you two go outside and figure out what the hell we're doing here? And they came back in and they dismissed the case. And so this is unusual. I certainly have had folks at an uncontested hearing. I've had folks change their minds. As a lawyer, I certainly have people reconcile, for sure. The most common reason, see, the problem with defining what the most common reason for divorce is, even like in my, I guess you could call this a pretty wide spectrum of opportunity to evaluate this. I haven't kept track. The problem is, it's never about what it's about. So, if you get they cheated on me, or they lied to me, or they ignored me, or whatever that is, there is so much, that's just the tip of the iceberg. There's so much under that that I wouldn't find it to be credible. So I think people quit talking. I think people quit talking. Is, I think, one of the most simple, unelegant, unsexy, I think people just quit talking. Horrible things that happen really, really rock marriages. Things that happen to their kids really rock marriages. I see so many marriages not be able to survive horrible things happening to kids. So it's just it's just kind of all different stuff. It's all different stuff. What shocks me is not that people break up. It's not that people decide that they can't be together. What shocks me is forgetting what it is in that other person that led you down. Like, you got a dress, and you paid a caterer, and you know people flew in. Well, and to be at that, as acrimonious as I see them get, that's what I don't get. Like, I just can't imagine ever feeling that way about anybody I've ever loved. I can't imagine having that big a turnaround. So that puzzles me daily. Yeah.
Would you care to touch on a case where one person definitely doesn't want the divorce and the other person does want the divorce?
So is somebody, I always refer to this as like the emotional arc of divorce, and somebody's always way out ahead. And usually the person who files, not usually, a lot of times, the person who files, this isn't like they woke up one day and went, oh, going to go down and get a divorce. No, they've had all this time to get themselves to that place. And so they're like, I'm on my road to freedom. And the other person's like, wait, what, huh? So one person is definitely usually behind. And sometimes, but I'm really glad you asked that question, because this is one of the reasons that divorce can take a while, and it's the reason sometimes that it's okay that it does. Sometimes people just aren't ready, and they're arguing about things that really aren't what it's going on. They're just not ready. And at the point they're ready, then all of a sudden we can divide the pots and pans, and then all of a sudden the timeshare is not a big deal, and then all of a sudden an apartment in Dubrovnik's really $100,000, and you can actually get it done. But that is it's a big element. The emotional stuff is a big part of it. It's not something that the system is very good at dealing with, but it's kind of everything when you think about it. These are disintegrating relationships. Pots and pans and dogs. Oh my God, I hate pots and pans and dogs. So dogs are considered personal property. So I can't do custody orders. I can't do an evaluation as to who's the best mommy. We're supposed to treat these things like property. Those get very, very difficult because people love their pets, as we all do. So, yeah, what's your question?
On the prenuptial agreements that are enforceable,
Yeah.
I had heard that it would not include your home, like let's say people who already have their homes, the kids are growing, and the house is in that person's name only now, and they get remarried later on. Is that home, even if it's in the prenuptial agreement, is that still going to be made up? They wanted to keep it separate. Like, hey, if we happen to get a divorce, then the house stays with the kids.
Okay, I'm gonna try to answer that question, and then you tell me what part I did not answer. Mm-hmm. Prenuptial agreements or can be agreements you make before you get married. Mm-hmm. They can be agreements you make after you get married, but before anybody files for divorce. It can happen either way. There are some differences in how they are enforceable, but they are all enforceable. In the state of Florida, they are treated like contracts, and they are absolutely enforceable. So if, as an example, you had a prenuptial agreement where I said, soon to be hubby, this is my house, but I want this to be our house, this will be our house, then it's going to be our house. If I say, soon to be hubby, this is my house, you give me, but you don't get my house, then if it's in the contract, then he won't get the house, I'll get to keep the house. So it's about what's in the contract specifically. Now, if we have a prenuptial agreement that says what's mine's mine, what's yours, yours, and we get married, and then we buy a house together, that's a marital house.
Right.
So it really is about how the contract is written, what's included, what's not included, and things that you acquire while you're married that are not specifically included in that agreement, they're still marital.
Okay,
Okay, does that answer the question
I think so.
sufficiently?
Thank you.
I thought I saw, no, maybe, no. So, yeah, people do like to, not always, have fights about who gets literally down to, I've had lists of down to the towels. I've had lists that included art from the mall. Who was that artist that did the art that had the light? And it'd be he was in the mall and there'd be like, everything was lit up and it was like oil paintings and he was supposed to be the master of the light. Or I've had that trial. I did have a cow trial. So the parties were married 20 years, lived on a ranch, a cow ranch, and there were a handful of cows. Is that you? I think that's you. There were a handful of cows that the husband said were not marital because he had them before the marriage. They were married 20 years. I'm like, how long did cows live? I mean, I'm not a cowgirl, obviously. So we have a hearing, and the neighbor came in, and they had a adjoining fence, and she was over in the, I don't know, back 40 or whatever you call it. She had a house over there, and she said that these particular cows, the really old cows, I guess, would come over to her fence and visit her on occasion, and she knew them by name. And she was absolutely positive that those cows were around before these folks were married 20 years ago. So I asked the husband, I said, well, but the cows, like you fed them with marital food. And I mean, you kept them alive for 20 years with marital stuff, their vet bills. And he's like, well, no, they ate the grass. I'm like, oh my God. So people, of course, again, it was not about what it's about, but people will litigate very bizarre things, some super bizarre things. So the pots and pans we all hate that topic. We all hate that. I generally try to make them make a list and then make them each pick so that I don't have to value these things. We talked a little about alimony. There's a formula. We all love a formula. Child support is also a formula that's got basic things in it. Enforcement is really something we spend a lot of time on because it's one thing you have an agreement or you go to trial and the judge makes this big order. Fabulous until somebody doesn't do it. And so we spend a lot of our time trying to get people to do the things that we tell them to do. And so this is probably 50% of my time, to be honest. So I write pieces of paper and then people ignore them, and then I have to call them on the carpet and try to get them to follow the pieces of paper. So contempt, you can only use when it relates to child support, alimony, or doing things or not doing things that you're supposed to. So when I can use contempt, that's super handy because that means I can put people in jail, and putting people in jail is very effective. Very very, very effective. When you can't put people in jail and they figure it out, things get less effective. So in the House example, marital homes are a big problem because, of course, they're usually people's biggest assets. And so it would be very common that I would say, this person is going to keep the house, but they've got to refinance it to buy out the other person because they're going to owe them often hundreds of thousands of dollars. Well, that payment of the hundreds of thousands of dollars, I can't use contempt to enforce that payment. I can use contempt to enforce do the steps to go get a refinance, but I can't do it for the actual payment. So it's super frustrating when people owe others money, which is why sometimes we resort to requiring the house to be sold. Because if the house is sold, then I don't need to worry about it. Everybody's getting their money and walking away. Nobody's stuck on a mortgage in somebody else's name, and it just makes things simpler. But that's hard these days because we've got everybody who's in a house that got an interest rate a number of years ago. They're in an interest rate 2-3%. That's amazing. That's amazing. Now you're making them go take their money out of the house, go buy a new house, and now they're both going to be in it. I don't know, what is it right now? 9%, 40%? I don't know. So it's there's just a lot of things to consider when dealing with how is it fair? Do I trust this person to do what I'm going to tell them to do, or is this person going to not get their money and have to chase it down for the next 2 years? And so there's a lot of trying to evaluate what people will do, because the best solution sometimes requires me to trust that they're going to follow my order. And that is a little bit scary sometimes. Modifications. So all kids stuff is modifiable. The schedule, the time-sharing schedule, parental responsibility, meaning who gets to make decisions about what things. All child support is modifiable, and all alimony is modifiable. So you need a substantial change in circumstances. It's built to be difficult because otherwise people would just change their mind every other minute and they'd want to change it back and forth. So it's built to be difficult, but you can modify those things. And we have a lot, that's a big part of our job too, is dealing with people want to change things as situations change. The money issues are particularly difficult, as you can imagine. The change in circumstance needs to be permanent, and it needs to be involuntary. So deciding that you want to quit your 6-figure job to go back to school, that's not involuntary. You can't get a modification for that. Having a job that's interrupted for a very short period of time, that's not permanent. You can't get a modification for that either, although you might in some situations be able to do a short-term or a temporary modification. But the money stuff is challenging, particularly when you have self-employed people, as we talked about. It's very, very tricky. Or retirement. So you are entitled now under the law to a modification of support that you may owe at kind of reasonable retirement. And even now, with the newest change in the law, you can apply for a modification for a retirement that you're going to take in the next 12 months to try to make it, it makes it easier for folks who want to retire but are paying, particularly in alimony situations, an alimony award. So, any questions about any of that? What? No, okay. Evidence. So people want to show you their cell phone all the time. Be like, well, did you bring the XYZ? Nah. Well, do you have that? So I can't look at cell phones because anything I look at, it has to be taken into evidence and given to the clerk and marked with a stamp and kept in wherever it is they keep those things, down in the bowels of this building somewhere. Now, every once in a while, don't tell anybody, do not tell anybody. every once in a while, give me that darn phone. Because you just got it, sometimes you just got to know whether something is or is not. But you're not supposed to take the phone because you got to put it in evidence and nobody wants to lose their phones. The people want to bring in all sorts of things, as you can imagine, that have nothing to do with anything because they're unhappy with each other. So you got to sort through that. And then the issue of hearsay. So you're going to be law school graduates in the next 2 minutes. So hearsay is a witness repeating what somebody else said that's not in the courtroom. And the reason that you don't allow hearsay is because that person who said that thing is not there for us to question. So this is very difficult for lay people to understand, and I totally get it. Unfortunately, it means that lots of things that pro se litigants want me to look at, I can't look at. I can't look at police reports. I can't look at DCF reports. I can't look at teacher letters. I can't look at neighbor letters. I can't look at grandma letters. I can't look at letters. If it's a letter, I can't look at it because that's somebody else that is not in the courtroom giving me information, and I can't question them about it. So it's that concept is just really that simple. If it's somebody outside the courtroom telling the judge something that the judge can't question them about, you can't use it. So that is challenging, and one of the areas that really worries me when you've got a lawyer in one case and not a lawyer on the other side. And so generally what I do is I let the lawyers know that everybody's going to have the same rules. So if they want to sneak in some hearsay because that person doesn't know to object, that's okay, but that person's going to get to sneak in the same kind of hearsay. And so at least kind of keep it fair as to who's getting what in. But this is an area of a lot of, did you see they're having they're doing a little lunch and learn thing on hearsay? I think that's a great idea. All right, yes, please.
On the hearsay, if the party brought in the person so you can question them, would that be
So yes,
acceptable?
fabulous question. I should have said that. So for example, if I used a police report, instead of bringing in the police report, if they'd subpoenaed the officer who wrote the police report to tell me what he saw and did at the scene, absolutely fine. That is not hearsay. But that's a great point. You got to have live witnesses. So instead of the letter from mom or the letter from the neighbor or the letter from the teacher, you have those real live people. And that way we can question them about their bias or if they were in a position to know the things they say they saw or those kinds of things. So yes, live witnesses, always fine. Documents are where you start getting into the problem areas. That's a good point.
A mutual friend asked me to help a man whose wife had filed for divorce, and he was dyslexic. He couldn't read and he couldn't write. And so we watched Mid-Florida Community Legal Services has videos, so we watched them together. I asked him the questions. I filled out the forms. The departing wife signed off on what it was needed, and I think they got their divorce in like 8 weeks or 4 weeks. It was really quick. But at the end of it, it wanted to know if anyone helped him fill out the paperwork, and I was afraid to sign it because there was somebody lurking in the shadows threatening, and I didn't want my name to be associated with it. Am I bad? I mean, you know, like what is there a way to keep your, I would have done it if I had known there was a way to keep my name private, but I didn't want it in the public record where this person that he told me about.
So that provision that's on the bottom of most, if not all, of the approved forms in family cases is not there. It's not there for you.
Good.
That's there for like paralegal organizations that people pay.
Because I see the signs by the side of the road, divorce $99.
Right.
Okay.
Right. Right.
So, okay,
Right.
good.
You are not the person they're trying to keep track we're trying to keep track of the people who are getting paid for it so that we know when people pay for assistance that they might think is quasi-lawyer-y, is the reason that we have those on. And that's
Good.
so.
That
yeah,
makes me
you're
feel
good.
better. Yeah. So,
You're good.
yeah. After hearing this, I think I did a great job.
I mean, it sounds like you did. It sounds like you absolutely did. Yes.
Hi, my question might be outdated because it comes from experience like 40 years ago, but I was in a court scenario with my son and accusations were made, in the family, people being mean, and there go, we need psychiatric evaluations. And I thought that I recalled, again, I'm going 40 years back when I was in my 20s, but like that they used those, they said that psychiatric evaluations, they said, didn't resemble anything that was accused, and it was a factor, but I don't know if it was different then, or was it always?
So I think some things change, some things don't change. So the question is, do we utilize psychological evaluations and things like that? In some cases, those are utilized, but you have to really prove that there's a serious connection between somebody's psychological issues and their parenting to order that, and it doesn't happen very often. It's more often that we would get people involved like a parenting coordinator, for example. A parenting coordinator is somebody who is appointed by the court, the parties pay them jointly, and they work with them, have conversations about the parenting plan, have conversations about problems communicating, talk to them about disputes they have, flag football, no flag football, and they kind of help them learn some better techniques for communicating with each other. So I love those. I utilize parenting coordinators a lot. We have guardian ad litems that do investigations about problems. Is this a horrible problem? Is this not a horrible problem? We have social investigations, which are mental health professionals looking into kind of the dynamics of the family if things are really high conflict, try to figure out like what's going on. So we use much more often professionals to try to come to solutions than just going out and getting a psychological evaluation, which isn't going to give you a solution. It's just going to tell you what a diagnosis is. So I can't say those are never used, but for me, and I think most of the judges I work with, if we're going to use professionals, we want to be getting some solutions to some problems. And honestly, everybody going through a divorce probably needs their head examined. So I mean, it's just a very trying time. It's a very trying time. Yes.
Hi, Judge.
Hi.
My question is kind of a weird situation. So let's say you have a couple. That couple has been married, let's say 15 years is a good number. And within the 15 years, 7, they have lived apart, they have started other lives, they're calling other people hubby and wife, but they're still legally married. And children are now being created within that. How do you navigate through that part if it's a situation where the wife gets pregnant, but who she's pregnant from is not disclosed?
So the question is, the parties, married people separated for a very long time, and they go on with their lives, including children. This is pretty common, and so generally there's an agreement that the husband, who although the law considers to be the legal dad, there's generally an agreement that is not the dad, and the wife would file an affidavit. Hopefully, the real dad would file an affidavit, and then the final judgment would disestablish the husband as the father. Now, if the real dad is not willing to do that, or we don't know, if the husband and wife agree that the husband cannot be the father, and he has not acted as a father to the child, then the final judgment could still take him off the hook as being dad. If husband acts, if husband and wife act as if husband is the dad, they're married, he's a dad. He's a dad. So it's not a situation where husband can say, I'm going to raise somebody else's child while we're together, and then when we break up 5 years from now, I've decided that's not my child anymore. That's not going to work. Because the husband is the legal parent in the state of Florida under our law, unless you can disestablish him in one of these other ways. So it gets tricky. It gets very, very tricky. The disestablishment is a tricky thing. Yeah.
It was related to that. My
Yeah.
question was about the stepfather. So if a man marries a woman that has a child and also has a father somewhere else,
Once you have it, you can only have one legal dad. Once your dad's your legal dad, even though you become stepdad, new husband does not become your dad.
okay, so if they break up stepfather and mother, is the stepfather liable for child support?
If is the stepfather the father?
No, no.
Oh, I see what you're saying. No, like I said, once this is really getting confusing. Wait, no, the stepfather and the mother at some point were married, and he's the legal dad. They got divorced. New husband comes in. This guy's still on the hook. Only one person's on the hook, and once they're on the hook forever. Well, you know what I mean, not forever, but.
Hi, I have 6 questions. I don't know if that's too many, because I don't want to take up a bunch of other people's time.
Go.
Okay.
Speed
just
round.
Speed
No, I'm
round.
kidding.
Okay. So for you have your pro se process online, or like your final judgment without personal appearance, but that has signatures by attorneys at the end. Can pro se litigants do that?
Pro se litigants the question is, if you have an uncontested divorce, meaning you've got an agreement or there's nothing, and you're pro se, can you take advantage of the mail it in or email it in option? You can. Our case managers help people do that all the time. So our case managers manage all the pro se cases, and they are able to take advantage of that same situation, yes.
If they're using that form, though, like the Florida Supreme Court form, would they edit it to sign in the spot where attorneys are, or would they just sign where it says attorney signature?
Well, our case managers have taken that form and just taken that off of it.
Okay.
You could probably
Okay.
do it. I mean, I don't think there'd be anything wrong with having the parties sign it and then just leaving the attorney spot blank, honestly. There's nothing that requires it. There's a lot of Supreme Court forms that they try to make it the most useful for the most number of people, but there isn't anything magic about them. Like it doesn't have to be exactly that. They're more of a serving suggestion. You won't run afoul if you use it, but it doesn't mean that it always has to be exactly the way that it's laid out.
Okay, thank you. And in Orange County, are parties referred to mediation prior to any type of hearing, or do they go straight to a hearing if it's emergency or expedited?
Great question. The question is, at what point is mediation required? Mediation is generally required before a hearing of any type. But if an emergency motion is filed, and we hate emergency motions because they're never emergencies, and we are required to deal with them within 24 hours, we hate them. But it is possible. So when I get an emergency motion in, I look at it immediately. I will either set a hearing, expedited, the next week or whatever, or I will enter an order giving people direction as to what to do, or I'll enter an order denying it. But I have to do something about it. And sometimes those get set for a hearing before mediation. So a judge is, even a judge who has very, very explicit procedures on their website, which most of us do, we can do what we want. So if we feel the need to have a hearing because something looks very, very serious or needs to be dealt with, and sometimes I will set a hearing because I think they need to hear from me Like, somebody doesn't understand this 50-50 thing. Somebody doesn't understand that, this part of what our law is. If they have an opportunity to learn a little bit, then they're going to go to mediation, and they're going to be much more likely to settle because everybody will be on the same page, same sheet of music. So judges look at that different ways. So technically, yes, mediation is required first, but sometimes we give hearings without it.
Thanks. I have a couple more. Am I still
You're only
good?
on 3.
Okay. So can parties agree to revoke either part of or all of their prenups or postnups in mediation?
So the question is, can you undo an agreement if you're both in agreement to do that? Absolutely. It's a contract. You can rescind a contract by agreement, and you can rescind a prenup by agreement or part of a marital settlement agreement. Yeah, absolutely.
And is it legally binding if in their mediation agreement they say, we want to return to mediation before this child enters middle school or at the sale of our house or something?
This is a good question. So this happens a lot. The parties split up when the child is 2.5. And they live an hour and a half apart. And they say in their agreement, we're going to do an every other week or whatever with the child because they're not in school. And then we will go back to mediation at the point that they turn 4 or whatever month before they're going to go into kindergarten and try to decide where they go to school. This is very, very, very common. Yes, they can do it. Yes, it's enforceable. And it's not a problem except when they wait until, July 10th to say, we can't figure it out, do something, judge. But it happens with some frequency. So if your question is, will the judge always force them to go back to mediation? It would probably depend. So if they contacted me in July 1st, and said, we didn't go back to mediation like we agreed to, and school's starting in 5 weeks, I'd get them in there. I'd get them into my courtroom and get it figured out, because I don't have time for them to go to mediation and then get back, and then what are we going to do? But if that doesn't happen, then yes, that would be enforceable. That would be enforceable. And it is, but the second part of your question, though, is a little bit different. So can we agree to go back to mediation and talk about kid stuff? Absolutely, because kid stuff is always modifiable. The house thing's a little bit different. If your question was, can we agree that the house be sold, or that you have the house and then later we go to mediation to figure out what happens with the house, that's trickier, because once the final judgment is entered, I don't have authority anymore over the house. So that is a much more complicated problem, and there'd have to be we'd have to figure out how to do that legally. So I would say if you're a pro se person and you want to have a divorce and you've got something tricky like that, be really, really specific about what it is you're trying to accomplish, what date it is everybody has to do whatever they have to do by. And so the more detail you can have, the more easily it will be enforceable later.
Okay. I have one more.
Yep,
if
okay,
that's
go ahead.
Okay.
Go ahead, and then we'll go to Houston.
Is there a maximum amount of times that they can modify the same thing or the same order in a certain period of time?
So there is no maximum amount of time. If something is modifiable, say for example, child support, it's modifiable upon a substantial change in circumstance, theoretically, that thing could happen 4 weeks after the final judgment is entered, and then another one could happen a year from then, and another one could happen. I mean, there's no, you have to meet the standard, but you're not limited in time.
Thank you so much.
A couple have children, but they got a divorce without children. So can one of them come back later and file for child support? They have children, but some way somehow they figured out to get a divorce without adding the children to
Okay.
the divorce? Can they
They
come back?
are not rule followers. Yes, does it sometimes? Yes, it does happen. Makes me nutso, but it does happen. Those kids are still kids of of that marriage, and yes, not only can somebody come back and ask for child support later, arguably they could come back and ask for child support back. So it's a dangerous thing to do. You're not permitted to do it. You're sworn. The petition for dissolution is a sworn document, meaning you are swearing that when you hit the box, there are no children. That's what you're swearing. So you're going to be in trouble. It does happen on occasion. It does happen on occasion. Yeah.
Just very briefly, when you spoke about mediation, let's just say in a pro se outcome case, is it still mandatory to attend mediation?
If pro se, well, if anybody represented, not represented, has all their paperwork done, has a complete parenting plan if they've got kids, has a complete marital settlement agreement, they do not have to go to mediation. And sometimes people do absolutely do that.
With child sharing, time sharing, is there a maximum distance parents can be apart? Can one live in, say I'm going to move to Georgia? Or do they have to stay in Florida?
Great question. So I'm going to answer that in a couple different layers. So one question people have is like, how far apart is too far to do like the 50-50 thing? And that kind of varies, because you know if you live around this town that you can be 10 miles apart and be 40 minutes apart. So it really, like, some of that has to do with practicalities, schedules. Are you on 408? Or are you talking, how do you get to where you have to be? So that is generally kind of up to the judge, and it kind of varies. I feel like if kids are going to be in the car going to school for, more than an hour, that starts to get really kind of onerous for those kids. But to your bigger point, once a petition for divorce or paternity is filed, once it's filed, nobody can move more than 50 miles without written permission by the other person or a court order. So once it's filed, you are stuck in a radius. Now, 50 miles is a pretty long way. 50 miles that could be easily an hour and a half, depending on which direction you decided to go out. So it can still cause problems, but we have a relocation statute that prevents people from just up and moving kids away. Actually, it prevents anybody from moving. So even if you're not taking the kids, you're still supposed to get permission, because you moving that far away is going to make it difficult for you to share in the load of parenting that the other person has. Yes?
What do you do if a child wants to go to a certain school, but the parents they want them to stay like in the district that they're in? What do you do about that?
So the big part of your question is, what do you do about things kids want? And I try to be pretty careful, because I think kids a lot of time don't generally want what's good for them. A lot of times, but I don't know that I've ever had a situation where the parents wanted one school and a child wanted another. Parents rule in that situation. I'm not going to side with the child against both parents, for sure. And school is that's a thing. I'm not sure I'd trust many children with that topic. Yeah.
So if your child was in private school,
Yes.
parents are getting divorced, how much weight would you give to the fact that the spouse has to contribute towards the private school? Because that's
As far as
tuition for the private school. So children in private school,
So what
parents are getting divorced, right? Yeah.
Yep. So if your child is in private school and has been historically in private school, and it's reasonably affordable, unless there's some other huge reason not to, then generally that child's going to stay in private school. The problem is that you can't run two households on the same money that you can run one household. And so sometimes, sometimes it no longer is affordable. But the law generally is, if it's reasonably affordable, and that was the culture, the history of the family, you generally want to keep kids having the same opportunities they had when the parents were together, if reasonably possible. So that'll vary. Yeah, hi.
Yes, grace and peace, Your Honor. I have a question. If the parent who has the children most of the time, are they allowed to keep the children away from the other parent for the timeshare? Because it's a situation where I know someone where they just got out of prison, and according to their divorce decree, they're supposed to have 50-50 time with the child, and now the mother is saying she doesn't want the children to be around the father.
So there's a divorce decree that gives him time sharing? In my world, the court order is a court order. So what she could do, if the thing that caused the jail is potentially going to impact parenting, she could file a petition for modification. But that would be the safest thing to do, is to file a petition for modification.
Just took the kids from home, tell them where the kids are or anything.
Yeah, well, that's not generally in keeping with what is expected. So yeah, that's court orders are court orders until the judge changes them.
Can she be held in contempt and might get in trouble, or?
Yeah, absolutely. Yeah, as I said, 50% of my day. All right, are we? Oh, he's right behind me. Jesus. Creep.
Thank you, Judge Tennis.
Thank you. Thank you. Thank you.
I found that incredibly enjoying. I hope it was interesting to everybody as well. I have so many questions. I'm going to rattle off 2 or 3. I'm not going to get an answer because hopefully we can get Judge Tennis to come back in the future. If a spouse inherits a bunch of money during the marriage, is it now a marital asset? Okay, if your spouse is in jail or prison, is that a good time to seek a divorce? Is that going to make it easier, or will it make it harder? While this is going on, can I take my children on a once-in-a-lifetime vacation if it's going to take 3 to 4 weeks? There's so many things we can cover here.
So many specific questions that you have that make me wonder, what's going on with you, Bob?
But thank you so much, Judge Tennis. That was fantastic. I want to thank everybody again. By the end of this year, we will have next year's agenda in place, so you should be getting notification by email or whatever, carrier pigeon, whatever we're using these days. We'll do that, but we sincerely thank you for being here. If you need any help, Franny's right there at the door. We look forward to seeing you next year, we hope. Okay, thank you.